evening, everyone. My name is Olivia Davis, and I currently serve as the Speaker of the Senate for the Student Government Association. And on behalf of everyone that went into planning tonight's event, I just want to thank you all so much for joining this event in partnership with SGA and UA's Title IX office. Earlier this year, the U.S. Department of Education released new regulations governing campus sexual assault under Title IX. These policy changes are covered throughout a very lengthy document, which has been researched extensively by our own Title IX office serving the UA campus community. To ensure that students remain informed on the resources available to them through the Title IX office, we will now briefly explain the ways in which these changes are being implemented at the University of Alabama. Thank you so much to Jessica Umber and Beth Howard, who are joining us on tonight's call from the Title IX office to present this information, and I'll go ahead and turn it over to y'all.
Hi, everyone. I'm Beth Howard. I'm the Executive Director of the Office of Equal Opportunity and Title IX Programs, and I'm very happy to be here with you tonight to talk about these regulations. I know Jessica, myself, and many others at the university worked really hard this summer to try to interpret those regulations and put them into a policy that works best for our campus. So we're really happy to be able to share that information with you and also share some information about our office. Jessica, I can't remember if you said you added this to a slide, so if you did, we can just skip over it real quick and I'll go ahead and say it now. But in November, the Title IX office merged with the Office of Equal Opportunity. So if you ever need our services, we also receive reports of harassment and discrimination based on what are legally protected classes, in addition to handling all of the Title IX reports. Now, I know this presentation is about Title IX, so I wanted to, turn this over to Jessica Umber. She is our Title IX coordinator to do the bulk of the do the bulk of the presentation going forward.
Thanks, Beth. Like she said, my name is Jessica Umber. I'm the Title IX coordinator. Very excited to be with all of you tonight. And we will try to give you just kind of a brief overview of what our office does, as well as how we have implemented these new changes that came out in May 2020. It was a lengthy summer trying to do all of this in the middle of a pandemic, but I'm very pleased with our finished product and think that it serves our students and our campus community well. We have put together a PowerPoint presentation I'm going to share with you guys to kind of walk you through it, and then of course we'll be happy to answer any questions that you guys might have. So let me go ahead and share that screen so you can see. Okay. All right. So to get started, this is a current list of our office staff. Like Beth said, we did merge in November of 2019. So our office is growing and continuing to grow. We have recently added a new position. This ombudsperson informal resolution facilitator is a new position that recently started last week. And then we are also in the process of adding a director of equal opportunity. So our office is continuing to grow and change to meet the needs of our campus community. Our contact information is listed on our website. You can find this at any point in time. And I think during the question portion of our presentation, I'll go back to this slide and put that up in case any of you want to contact our office with any additional questions or to make a report, or if you need assistance with anything. So just really briefly, we'll start off with, what Title IX is. And I think that, when a lot of you hear Title IX, or when a lot of people hear Title IX, they immediately think of, gender equality and athletics. And that is certainly part of what Title IX is. But it's been around a long time. It was enacted in 1972, and it has been interpreted over the years to include things other than gender equality in sports. It has been interpreted through regulations, case law, that type of thing, to also mean that universities and other, institutions that receive federal assistance, there's a prohibition against sexual harassment in their education program or activities. And so since UA receives that federal financial assistance, we have to be compliant with Title IX. And so that prohibition of sexual harassment applies to us as well. So generally what this means is that we have to adopt certain grievance procedures and processes and offer supportive measures to our students, our faculty, staff, campus community. And we have to have those in place in order to address these reports of sexual misconduct that would fall within the requirements of Title IX. So that's just generally why our office is here. And we'll talk a little bit more in depth about what these regulations did for the current policy that we have in place and how we've implemented those changes into the policy. So like Olivia mentioned, in May 2020, the Department of Education released these final rules and their regulations that impact how Title IX applies to educational institutions like the University of Alabama. So we have always had kind of guidance documents that have informed our way of how we interpret Title IX. But these regulations were pretty groundbreaking because they actually have the force of law. And they really set forth some specific things that universities are expected to do in order to comply with Title IX as it relates specifically to issues of campus sexual harassment, sexual violence. We've had these guidance documents in the past that have always kind of informed us, but now we have these regulations that we have to comply with in order to remain, compliant and continue to receive that federal financial aid. And we were required to implement those by August 14th, which we did. It was very exciting. But there were 2,000 pages of regulations that we had to go through to get there. So it was quite a busy summer. But those regulations are now in effect, and they are in effect through our policy that's posted on our website. So just a general overview of the major changes that we had to implement into our policy. The Title IX regulations specified certain types of prohibited conduct that we had to address and that we have to respond to. But then it also said you may be able to respond to other types of prohibited conduct that don't necessarily fall within this category that the Title IX regulations cover. And we'll talk about that a little bit more and what that means on the next couple of slides. But it basically delineated certain types of prohibited conduct that we're required to address under Title IX. It also clarified that the university is required to address a report of prohibited conduct when the Title IX coordinator has actual knowledge of that report. So it clarified when the institution is required to take action on a type of report when it receives it. Another thing that it added, kind of a procedural requirement, is that it said before we can initiate any kind of formal process or informal process, the complainant, which would be, in criminal terminology, the victim, the person who is alleged to be the victim of something, when they sign a formal complaint. And basically that formal complaint says, these are the allegations that I have presented to the Title IX office, and I want the Title IX office to initiate these formal or informal procedures to resolve this report. So just making sure that people are aware of their rights and the procedures under our policy. And then from there, the investigation can begin if that is how the complainant wants to proceed. Another thing the regulations gave schools the option is to have a different standard of proof. We've always had the preponderance of the evidence, and the regulations said that institutions could make that decision to stay with preponderance of the evidence, or they could have a different standard called clear and convincing. I will go ahead and tell you that we chose to keep the preponderance of the evidence standard, so that is not a change that you'll see in our policy, but it was an option that the Department of Education did put out there in those regulations. For the reports that do fall under the Title IX regulations, one thing that the regulations specifically require is a live hearing with cross-examination at the conclusion of the investigation. And we'll talk about that a little bit more on a later slide. And of course, the final thing that the regulations specifically delineated is that informal resolution is an option in most cases. So like I said, we have added this informal resolution facilitator position to our office, and that is something that we are offering to our students, faculty, and staff as a means to resolve a report of prohibited conduct in certain situations. So first of all, we will talk a little bit about our policy and how we have implemented those changes that I just discussed on the previous slide. So we have the Title IX and sexual misconduct policy. Again, it's found on our website, and you can review it if you would like to do some light reading on a Wednesday night. But this policy addresses how the university will respond to reports of sexual misconduct. and it incorporates a lot of these new requirements incorporates the requirements under the regulations. So one thing, there were some changes that came out in the regulations, but in a lot of ways, our processes have remained fairly unchanged. So our policy still jurisdictionally says, we cover all on-campus conduct, and we also cover off-campus conduct if the individual, accused is affiliated with UA in some way, whether that be student, staff, faculty, something like that. And it also covers, things that might happen, maybe not on campus, but at a UA event, such as or in a UA program, such as like a study abroad program, something like that. So we still cover all of that type of conduct. The difference comes in how that report is handled. So we have two different processes under our policy. One is called the Title IX process that follows the Title IX regulations. And then if the conduct does not fit within the parameters of the Title IX regulations, we have the sexual misconduct process. Those processes are nearly identical up until the time when an outcome or determination is made. And like I said, we'll talk about that in some later slides. But regardless of the processes that are in place, all of our students, so all of you, are bound by the Title IX and sexual misconduct policy. It's considered a violation of the Code of Student Conduct to violate that policy. And so that is, when a student is alleged to have violated it, they are charged with a Code of Student Conduct violation. Okay, so like I mentioned, we did not change our standard of evidence. It is still a preponderance of the evidence. That means more likely than not, 50 plus a feather, just a little bit over that 50%. So that standard of proof did not change. And another thing that did not change that is required by the regulations, but was something that we were already doing, is that we provide supportive measures or resources to complainants regardless of whether they want to file a formal complaint or pursue an investigation. So if somebody has been the victim of sexual assault and they don't want to pursue any kind of formal or informal process with our office, but they need academic assistance or they need assistance with obtaining safe housing, that is something that our office can offer even without that investigation. We cover different types of prohibited conduct. I've got it all listed right here. If we had more time, I would go through all of these extensively and give you a bunch of examples. But one thing I do want to point out is that the first 5 types of prohibited conduct that I've got listed here, those are the types of prohibited conduct that the Title IX regulations have specifically said are covered under Title IX. So these last 3 are not considered prohibited conduct, under Title IX, but our policy still covers them as prohibited conduct under our policy. So that's something that we can still investigate and look into. Again, it just might be under a different process. Okay, so one thing that that I mentioned that did change, and it not really change, it was just more of a clarification that the regulations offered, is reporting and how those reports are handled by educational institutions. So the regulations clarified how the university is put on notice of a report. And the regulations said, when the Title IX coordinator has actual knowledge of a report, then the institution has to take some sort of action to address that report, whether that be through an investigation or offering supportive measures. Now, we encourage everyone, student, staff, faculty, community member, anyone that sees prohibited conduct occurring, we encourage them to make a report to our office so that we can offer a complainant those options and supportive measures, with our office. But in order for us to take those kinds of actions, our office has to be notified of that type of report. There are a few offices on campus that are required to report to us. So the Office of Student Conduct is an example that would impact students most frequently. So if the Office of Student Conduct becomes aware of a report of prohibited conduct under our policy, they'll contact us. But again, we encourage all individuals to contact our office so that we can provide those supportive measures and options to complainants. Okay, as I've alluded to, one of the big changes from the regulations is the jurisdiction to address reports. And even though this was a big change under the regulations, our office has not changed in how we handle those reports. We've just simply delineated 2 processes to handle them. So we are still handling all of the same things. Again, there's just a different process that's in place. So for either process to apply, there are certain criteria that have to be met. And I've got those criteria listed here. I won't bore you with reading out all of them, all of the different requirements, but I will tell you that, in order for that Title IX process to apply, it has to be one of those 5 types of prohibited conduct that was on our earlier slide, and it has to occur within the United States in an educational program or activity, and the complainant has to be participating or attempting to participate in some sort of UA educational program or activity. Otherwise, the sexual misconduct policy, more likely than not, would kick in and cover that type of conduct. Both of these processes begin with the signing of a formal complaint. So if we receive a report to our office, we're going to email the complainant a list of options and supportive measures that are available to them. And then if they would like to start any kind of formal or informal resolution processes, they can sign that formal complaint, and that would begin both of those processes. And so we'll kind of go through a couple of examples to help illustrate that. It's a lot easier to understand how the jurisdiction works through an example. So let's just say that the complainant alleges, comes to our office and says that a respondent sexually assaulted her by penetrating her vagina with his penis without consent. Okay, so that is something that would be covered under Title IX because it would be considered rape. So that is Title IX prohibited conduct. She says that the incident occurred in a residence hall on campus and both of them are students. So we have jurisdiction to take, informal or formal action if the complainant wants to. So if the complainant were to file a formal complaint, this would probably fall under the Title IX process because the incident occurred in a UA program or activity since it occurred on campus. Complainant is participating in an education program or activity since she's a student, and the alleged conduct is considered sexual assault, which is one of those types of Title IX prohibited conduct. So from there, the complainant has the option to file that formal complaint and request that we investigate and can receive those supportive measures. The complainant can just request supportive measures and does not have to file a formal complaint. They don't want to have an investigation, or if the complainant doesn't want to report, the complainant doesn't have to report to our office. We want complainants to have the power to contact our office and decide how, what they want to report and then how they want to have that report handled. So, most of the time we want that power to remain with the complainant. So, generally that rests with the complainant to make that initial report to our office. All right, our second example, let's say everything is exactly the same, except the incident didn't happen in a residence hall. It happened in an off-campus apartment that has absolutely nothing to do with the university. So this case would likely fall under that sexual misconduct process because it didn't occur in a UA education program or activity. Since it didn't occur in a dorm room, it's just an off-campus apartment. Again, complainant has the same options, it's just going to be under a different process. It would be under the sexual misconduct process, not the Title IX process. And then our last example, same set of facts, but let's say that the complainant is a UA student. It happens in an off-campus apartment, but the respondent isn't a UA student, isn't affiliated with UA at all. In that situation, we would not have jurisdiction to investigate because we don't have substantial control over the location where the incident occurred or the individual involved in the report. But there are still options. So the complainant can, number one, choose not to report to us, or number two, if the complainant reports to us, can still get that assistance with supportive measures. That could be, again, academic assistance, it could be safe housing, those types of things. Okay, so really quickly, we'll talk about investigations and kind of how that looks under the new policy and what you can expect. So regardless of which process applies, the investigation is largely the same. And the investigation is used to make the determination, whether a policy violation more likely than not occurred. And again, that process is going to be the same for both processes. So, our investigators would talk to both parties. They would interview witnesses. They would gather as much information as they can, whether that be, documentary evidence, video evidence, photographs, whatever that might be. And At the end of the investigation, both parties would have an opportunity to review that evidence and respond to it before a final determination is made. So the investigator is going to gather any evidence directly related to those allegations and allow the parties a chance to respond to it. The complainant and the respondent can have a support person or an advisor with them in any of their meetings. That advisor can be an attorney, but it doesn't have to be. It could be a parent, it could be a friend, anybody that can provide that support and serve in that advisor role to the party. And again, at the end of that process, getting a chance to review and respond to that evidence before the final determination is made. So this is where the two processes diverge, is the outcome stage. So under the Title IX process, once an investigation is complete, the investigation would be referred to a live formal hearing. And that is where a neutral decision maker is going to make a determination using our standard of evidence to determine responsibility and, if applicable, to determine sanctions. From there, both parties can appeal the outcome of the formal hearing. Under the sexual misconduct process, it's just a little bit different. The Title IX coordinator is actually, that would be me, is actually going to make the determination initially of responsibility and recommend sanctions if applicable. And then from there, both parties can appeal that decision by requesting a formal hearing. So in both processes, both parties are notified of the final outcome and have that opportunity to appeal further from that initial determination. So there are a lot of similarities in those processes. Under both processes, both parties can also request that it be resolved through informal procedures. So like I've mentioned, we've added the informal resolution facilitator position to our office. So once a formal complaint is signed, either party can request that the complaint be resolved through informal procedures. Now the catch here is that both parties have to agree to this. So we have to have the complainant and the respondent voluntarily and willingly agreeing to participate in this informal resolution process. And our office has to determine that the report is appropriate to resolve informally as well. This is, just an alternative way to resolve cases that doesn't involve the full investigation, or a hearing or a final outcome being made. And this process is going to look different depending on, the facts of the case and what the parties want out of the informal resolution process. Informal resolution is not available in cases where there is an employee, respondent, and a student complainant, but is available in most of our other cases. So that is something that we do offer, and we will have more information about that posted on our website, but something that we do currently offer. Okay, and so as I've mentioned, even if the complainant doesn't want to go through this formal or informal process, we still offer those supportive measures. So if a complainant doesn't want to file a formal complaint, we can still offer those supportive measures to the complainant. And that's even regardless, even if we don't even have jurisdiction to investigate, we can offer those supportive measures. So the common examples would be academic support. So if somebody has a court date related to a rape case where they are the victim and they're going to have to miss class because they have to go to their court date, we can provide that academic assistance to excuse the individual from, to ask the professor to excuse that individual from class. We also offer housing assistance such as safe housing, safety planning like no contact orders, referrals to counseling. If you ask us, we will figure out a way to try to find, a way to help you or find an office that can help you. You just have to ask the question and we'll figure out a way, to either help you or get you to the right office. Even if a complainant is unsure of what they want to do and whether they want to proceed with any kind of formal process, we still encourage them, to report to our office because, like I said, we want to give the complainants the power to decide how they want to move forward. But we want to make sure that they have all the information that they need in order to be able to move forward. So we want to tell them about the options they have with supportive measures, and the options that are available to them through the formal and informal processes. Okay, we have more information on our website, and we are constantly updating our website to give you guys more information about these changes and how they are being implemented. So there are certain tabs on our websites. We have flowcharts that we have worked on that kind of illustrate how this process works in real time. You can find those under resources and forms. We also have some helpful links under the supportive measures tabs that offers information about the supportive measures that our office offers, how to file a criminal report, the resources available in our community, several different things. There's a lot of information on that tab. You can also find all of our policies, so current and past policies. You can also use that website to request training and find more information about the training our office offers. Okay, so just to kind of summarize the key takeaways from the regulations and from the presentation tonight, we want to encourage everyone to report to our office. Reporting to our office starts a process that gives complainants some really important information about supportive measures that are available to them and how they can use our process, to work through these issues. In most cases, the complainant decides, number one, whether to even make a report to our office, and then number two, once they report, whether to proceed with that investigation. The complainant always has that initial decision to make about whether to make a report to our office, and generally keeps that ability to make the decision of whether to proceed with the investigation. Students are not required to request an investigation with our office to receive those supportive measures, and that would include issuing no contact orders. That's something that we can do between students that requests or requires both students not to speak with each other or contact each other. Investigations under both processes are largely the same, and again, really only diverge when it's time for an outcome to be made. And when we investigate something, both parties have the ability to review the information that we have gathered during the investigation and respond to that evidence before we actually make a final decision. So I think I have given you guys enough information to think about for a really long time, but we are happy to answer any questions that you might have. We just thank you for listening to us tonight.
Thank you so much, Jessica, for presenting all of that really important information. And thank you to both of y'all for putting together this presentation. It's definitely a resource that I think will be really beneficial to students. I do have a couple of questions for y'all that we had submitted previously by students, if y'all are okay to answer them really quick. Okay, perfect. Our first question is, what areas are considered on campus versus off campus? What specific locations must incidences occur at in order to constitute as an on-campus offense to allow for someone to file with the Title IX office?
Do you want me to take that one since you just—
Yeah, you take that one.
Okay.
Yeah.
That's actually a very complicated question. So there's a law called the Clery Act, and the Clery Act actually designates places that are campus or not campus, and the Clery Act guidance was recently rescinded. So I think for our purposes, what we would consider campus are, the campus things are buildings owned by campus, land owned by the university, and then also keep in mind that extends to off-campus programs and activities that are sponsored by the university. So if you think of, you are on the debate team and you go to a competition with the debate team, those activities could also be considered under the Title IX process because it's associated with a university education program or activity. But if something occurs and it's not on campus or off campus associated with an education program or activity, as Jessica was mentioning, those can still be reported. They might just fall under that separate sexual misconduct process. So they can still be reported, investigated. You can receive supportive measures for off and on campus. It just diverges there at the end when it's determined whether it would be referred directly to a live hearing or whether it would have that next step of having the determination made. And then it's up to the parties to decide if one is going to request the live hearing. But yeah, we actually, for our Clery reporting, we have conversations daily of, is this considered campus? So, that's a little different than what we're dealing with every day. We just look at whether this is a property owned by the university.
Thank you so much for that clarification. Jessica, did you have anything to add to that?
Yeah, I was going to clarify. So when we're talking about, with the Title IX process, kind of the touchstone of, when the Title IX process kicks in is, or part of it is, when there is a UA educational program or activity. And that is kind of defined by, again, whether the university has substantial control over the location, the event, and the person who is alleged to have committed the behavior. So that's substantial control. And that kind of goes into what Beth was saying of, it may not be on campus exactly, but if we have UA has substantial control over that location, and that still can be a complicated question.
Yeah. Definitely sounds like it. All right, our second question is, what are some other resources or offices that cover sexual misconduct if an incident does not fall under Title IX's jurisdiction?
Well, our office is the only office that covers investigations for sexual misconduct. There are other offices on campus, such as the Women and Gender Resource Center, that can provide confidential counseling and advocacy. And they also provide, some of the supportive measures that we mentioned without needing to, contact the Title IX office for that. But if a student or employee wants to make an official report to the university, and or request that a report be investigated, that we are the office that they'll need to go to.
Okay, those were the two questions that we have submitted. Is there anything else that y'all wanted to say before we hop off this call?
Well, I would just like to say I really appreciate the SGA for doing this. Over the summer when, Jessica and I were, doing webinars and trying to gather all this information, one of the things that, we talked about frequently was making sure that we got the information to students about what the policy changes are and their options and resources available to them. So I think events like this, the graphics that, you all put out today, help us immensely. And I greatly appreciate that you all care so much about this, that you're willing to take your time on a Wednesday night to, listen to Jessica give her law class, and to put this much effort in. I think it's a testament to how much you care about the university and your fellow students. So I appreciate that.
Well, we appreciate both of y'all immensely and all of the work that your office does as well. But I think that concludes tonight's event. Thank you both, Beth and Jessica, so much for joining us tonight. And if y'all have any questions, please feel free to reach out to them or the Title IX office in the future.
Thank you.